So what happens when a year-long labor protest doesn't just stay on the picket line, but lands right on someone's doorstep? Today, we're digging into a really intense legal fight between a resident of downtown Los Angeles and the labor union UniteHere. It's a fascinating case that puts the right to protest head-to-head with an individual's right to peace and quiet in their own home.
All right, here's how we're going to break this all down. First, we'll set the scene and look at the daily conflict itself. Then we'll get into the nitty-gritty of the 12 specific legal claims in the lawsuit. After that, we'll talk about the union's main legal counterattack, something called an anti-SLAPP motion. We'll see how the court applied its two-step test to that defense, and then, finally, we'll find out which parts of the lawsuit actually survived and were allowed to move forward.
So let's start in downtown LA. On one side, you have Abigail Katz, who lives there. On the other, you've got the labor union UniteHere Local 11, which was in a dispute with a nearby hotel. But the key here is that for Katz, this wasn't some abstract issue happening down the street. It became her daily reality.
And this was the union's rallying cry, chanted during their demonstrations. No contract, no peace. I mean, the slogan itself tells you everything you need to know. Disruption wasn't just a side effect of their protest, it was a central part of the entire strategy.
And we're not talking about a one-off protest here. According to the lawsuit, these demonstrations were happening almost every day for 401 consecutive days. Just imagine that. More than a year of loud, consistent protesting right outside your building.
Now think about the proximity. 161 feet. That's less than half the length of a football field. This detail is so crucial because it shows that for Katz, these protests weren't just some background noise in the city. They were an immediate, unavoidable part of her everyday life. Okay, so let's get into the lawsuit itself and see how this daily conflict got translated into legal language. Katz filed a pretty massive complaint against the union and a few of its members, and she laid out a dozen very specific grievances. Her lawsuit had 12 different causes of action, and they'd really covered a wide range. It went from things like private nuisance because of the noise, all the way to much more serious claims like assault, battery, and even false imprisonment. We'll get to that.
To really give the court a sense of what was going on, the complaint got very specific. It talked about the use of vuvuzelas, drums, and air horns, and alleged that the noise levels were hitting over 120 decibels. For perspective, that's about as loud as a rock concert or a chainsaw.
But the allegations weren't just about general noise. The lawsuit describes these really specific personal confrontations. For example, Katz claims at one point a protester blew a vuvuzela directly into her ear from just 1 inch away, an act that she said was both assault and battery.
And this is where it gets even more complicated. The union had filed for a restraining order against Katz, but she alleged that they then used that order as a weapon against her. Her complaint even quotes an LAPD report where an officer observed a union member harassing her by just loitering outside her home, basically using the legal order as a tool for intimidation.
So, facing this huge 12-claim lawsuit, the union and its members deployed a very powerful legal defense that's available in California, the anti-SLAPP motion.
First things first, what on earth is a SLAPP suit? Well, the term stands for Strategic Lawsuit Against Public Participation. Essentially, it's a lawsuit that's filed not to win, but to intimidate, to silence, and to financially bleed critics dry. So the union's whole argument was that Katz's lawsuit was just a SLAPP suit designed to shut down their constitutionally protected right to protest.
An anti-SLAPP motion sets up this special two-step test for the court. First, the defendants, the union in this case, have to show that the lawsuit is targeting their protected activity, like free speech. If they can do that, the burden completely flips. Then the plaintiff, Katz, has to prove that she has a real probability of actually winning her case. It's a high bar, and it's designed to get rid of frivolous lawsuits that target free speech fast.
Okay, so now let's see how the judge actually applied this legal framework to the very messy facts of this case. This is where the court had to carefully pick apart all the different things that were alleged in the complaint.
So for that first step, the court sorted all of the union's alleged actions into 2 different buckets. In one bucket, protected activity, it put things like general labor protests and the act of filing a restraining order. Those are protected. But in the other bucket, not protected, it put specific acts like the alleged assault with the vuvuzela or creating hazardous noise levels. The court basically said those things aren't speech, they're just conduct. So for all the claims that were based on that protected activity, like defamation or malicious prosecution, the court had to move to step 2. And the question became, could Abigail Katz show that she had enough evidence to probably win those specific claims if they went to trial?
All right, so let's get to the outcome. Let's see which parts of the lawsuit the judge allowed to move forward and which ones got knocked out by this anti-slap motion. The court's ruling was split right down the middle. It granted the union's motion in part and denied it in part. So, claims like malicious prosecution and defamation, which were tied directly to protected things like protesting, those were struck down. But, and this is a big but, the claims based on unprotected conduct, like the assault, the battery, and the private nuisance from the extreme noise, those were all allowed to proceed to trial.
The really important takeaway here is the distinction the court made. The right to protest is protected speech, absolutely. But the court found that this protection doesn't just cover any and all actions that happen during a protest. You have a right to picket, sure, but you don't have a right to commit battery or create a dangerous nuisance with 120 decibel noise.
So ultimately, this ruling doesn't give us a final answer on who was right or wrong. It just decides which questions are legally valid enough to even be asked at a trial. And it leaves us with that fundamental question that's at the heart of this case and so many others. In a free society, where exactly is the line between exercising your right to protest and infringing on someone else's right to peace? That's the question that will now move forward in court.